and welcome to a new episode of SCC Online Weekly Rewind. I am Nilufer and I have brought before you the most important legal news of the week. The top story of this week is from the Supreme Court, which has held that no individual can be forced to be vaccinated. In a landmark ruling on COVID-19 vaccination drive, the Supreme Court has held that bodily integrity is protected under Article 21 of the Constitution of India and no individual can be forced to be vaccinated. While the court held that persons who are keen to not be vaccinated on account of personal beliefs can avoid vaccination without anyone physically compelling them to be vaccinated. However, the court made it clear that if there is a likelihood of such individuals spreading the infection to other people or contributing to the mutation of the virus or burdening the public health infrastructure, thereby affecting the community at large, the government can regulate such public health concerns by imposing certain limitations on individual rights that are both reasonable and proportionate to the object being fulfilled. Consequently, till the infection rate and spread remains low as it is currently, and any new development or research finding comes to light, the court has directed all authorities in the country, including private organizations and educational institutions, to review the relevant orders and instructions imposing restrictions on unvaccinated individuals in terms of access to public places, services and resources. Saving over 90,000 reassessment notices issued after 1st April 2021, the Supreme Court has modified the order passed by the Allahabad High Court wherein it had squashed several reassessment notices issued by the Revenue, issued under Section 148 of the Income Tax Act, on the ground that the same are bad in law in view of the amendment by the Finance Act, which had amended the Income Tax Act by introducing new provisions, that is sections 147 to 151 with effect from 1st April 2021. Despite the amendment, 90,000 reassessment notices under section 148 of the unamended Income Tax Act were issued by Revenue after 1st April 2021, which was subject to a matter of more than 9,000 writ petitions before various high courts across the country. Observing that some leeway must be shown to the Revenue, as ultimately it is the public exchequer which would suffer, the court has passed Pan-India order that instead of quashing and setting aside the reassessment notices issued under the unamendment provision of the IT Act, the notices should be constituted as deemed to have been issued under section 148A of the Act as per the new provision section 148A, and the Revenue be permitted to proceed further with the reassessment proceedings accordingly. In a case where a student had completed 9 semesters of her academic course including clinical training in the medical college in China, but due to the outbreak of the COVID-19 pandemic, 1 semester was completed online and was granted MBBS degree without any practical and clinical training in physical form, the Supreme Court has held that without practical training, there cannot be any doctor who is expected to take care of the citizens of the country. Therefore, the decision of the National Medical Commission not to grant provisional registration cannot be said to be arbitrary. However, concerned with the fate of the student and other similarly situated students, the court has directed that the National Medical Commission to allow such students to undergo clinical training in India. Delhi High Court, while addressing the issue of whether visits of sundry family members to the matrimonial home would amount to permanency or the intention to treat the premises as a shared household would render them members of the shared household, expressed that just as the woman living fleetingly or casually at different places would not convert those places into a shared household, therefore the visits of family members to matrimonial home without permanency or the intention to treat the premises as shared household would not render them members of the shared household. expressing that the revisional jurisdiction is not meant to test the waters of what might happen in the trial. The Delhi High Court has held that at the stage of framing of charge, the judge is merely required to review the evidence in order to find out whether or not there is sufficient ground for proceeding against the accused. The bench has also added that every effort should be made to eradicate corruption, as at the end of the day it is the society and the downtrodden who bear the pangs of the corrupt acts of a few. The Delhi High Court, in a matter wherein the petitioner was aggrieved by the imposition of costs of Rs 5 lakhs for misusing the process of law and for causing inconvenience to the government machinery by the additional rent controller, expressed that unwarranted and needless hypersensitivity is not expected of judicial officers, who are expected at all times to maintain composure and poise befitting the office they hold. On 5th May 2022, the Ministry of Corporate Affairs has notified the company's Prospectus and Allotment of Securities Amendment Rules of 2022 in order to amend the company's Prospectus and Allotment of Security Rules of 2014. The amendment makes application under private placement compulsory for corporate bodies. The Ministry of Ports, Shipping and Waterways on 25th April 2022 has issued Marine Aids to Navigation Central Advisory Committee Procedural Rules of 2022 to introduce Advisory Committee for Marine Aids, which will be enforceable from 25th April. The Advisory Committee is established for advising the government in connection of policy creation and other business under Section 6 of the Marine Aids to Navigation Act of 2020. SEBI has issued a circular on system and network audit of market infrastructure institutions or MIIs. The SEBI has mandated that stock exchanges, clearing corporations and depositories should conduct an annual audit system by a reputed independent auditor. In order to keep pace with the technological advancements in the securities market, the existing system audit framework has been reviewed. RBI, the Reserve Bank of India, has issued master directions in the RBI credit card and debit card issuance and conduct directions of 2022. Enforceable from 1st July, these directions regulate the conduct of debit and credit payments in banking and non-banking financial companies. These provisions are not operative on payment banks, the state cooperative banks and district central cooperative banks. These directions aim to adapt friendly provisions for the credit and debit card customers and to introduce co-branding cards. The question for this week's quiz was under Creative Topics on SCC online database. How many treaties and conventions have been listed under criminal law? Name them. Answer to this question is for WTO, General Agreement in Tariffs and Trade, General Agreement on Trade in Services and SAFTA. Winners of this quiz are Rahul Yadav on LinkedIn and Gaurav Chaudhary on Twitter. Thank you for watching. Stay tuned next week for more updates.